Thank you, Jessica. And today we'll tackle what can seem like whiplash in the world of federal grants with additional requirements here, more flexibility there, potential rule changes, court decisions coming at you basically from every direction. And of course, did I read on X this morning that our funds are frozen? So there's no question that this can feel overwhelming. So for our agenda today, we'll discuss where these different directives, as I call them, are coming from, as well as their status and their significance. We'll give real-world examples of these different requirements or guidelines. And then probably most importantly, we'll outline some suggestions for protecting your federal awards in this unsettled environment. Well, if we're talking about federal grants, oversight, well, these are the branches that would dictate that oversight. The chart shows you the various branches of government, the vehicles that they use with respect to transmitting these requirements. And I should note that the federal agencies, of course, are part of the executive branch, but for our purposes, talking about grants management, they really have a very different role. But I didn't want you to think that we forgot about our social studies classes. So in terms of the executive branch, we've had a tsunami of executive orders with the current administration. And they're the easiest and the quickest action to take. But they can also be rescinded just as easily by a future executive. So executive orders really aren't designed to be permanent. And the OMB, or Office of Management and Budget, memoranda usually are issued to implement carry out the executive orders. And federal agencies, though, promulgate regulations and standards, but these are subject to public comment. These are usually published in the Federal Register. So they're a bit more sticky. They're not as easy to change as an executive order or reverse as an executive order. And of course, legislature or the Congress enacts the laws. They also have the power of the purse. So the budget resolutions will be laws, but as they say, your budget reflects your priorities. And then, of course, the judiciary or the courts interpret the laws, and these are pretty difficult to reverse, particularly if you're talking about a Supreme Court decision. And the judiciary or the courts are playing a fairly significant role in the current landscape, probably more than usual. And for that reason, I wanted to give a little refresher here about the federal court system. So the district courts in the federal system are the trial courts, and there are 94 of those throughout the country. You can appeal a legal issue from your trial to the circuit court. And Circuit Court of Appeals, 13 of those throughout the country. And to a great extent, these are the final interpreters of the law. They review your trial decision and affirm or reverse that. But as you can see here, 30,000 to 40,000 cases are filed per year for appeal in the circuit courts. The Supreme Court, on the other hand, takes 70 to 80 cases to decide. So there's a very narrow funnel from the circuit court to the Supreme Courts. And that's why, as I say, it's pretty much the circuit courts that interpret the laws for our country. And if the Supreme Court does hear your case, that's it. There's no more recourse as far as the judiciary goes. That's the final opinion. And in a moment of rare humility for a Supreme Court justice, you see this quote from Robert Jackson, Justice Jackson, who actually wrote this in an opinion. And he said, "We're not last because we're infallible. We're infallible because we're last." Now, because many of the DOGE efforts, things like terminating departments or terminating programs, wind up in the federal court system, starting in the district courts, I wanted to clarify the term injunction because you'll be hearing that or have been hearing that quite a bit when these issues are taken up in the federal courts. And I'm going to pause for a moment so you can read this slide because it is pretty packed with information. So an injunction is a court order to maintain the status quo until a matter can be heard fully by the court. And the purpose of that is to avoid irreparable harm. For example, if the court were to allow funds to be terminated for a child care program without significant warning, and that seems to be the way these things pop up. Well, without significant warning, what happens to the beneficiaries? What happens to the children? What happens to the daycare providers? What do parents do? You know, if they're going to be out of pocket funds or miss days at work, that's really, you know, more like a harm that's a significant harm, perhaps irreparable harm. So what the court would tend to do is until this funding issue is litigated, they would maintain the status quo. So unless, in our case, the government could show that it would be harmed more than the beneficiaries in the program by letting the funding continue. And when you file for make a motion for a preliminary injunction, you have to satisfy certain criteria. You can't just request this. You have to, as I alluded to, you have to present evidence that without a pause, there would be irreparable harm to your plaintiffs. And there's a key point about preliminary injunctions that you should remember in the second bullet, because the court hearing this preliminary injunction motion views the plaintiff as having a likelihood of success on the merits in the underlying case. In other words, for a judge to grant you a preliminary injunction, he or she, looking at the papers in front of them, think that you'll probably be successful for this underlying case. So it's early, obviously it's preliminary. The judge hasn't seen all of the evidence, but at this point, you have the balance seems to favor the plaintiffs. So keep that in mind as you hear about preliminary injunctions being granted, what that could mean. And the public interest is served by granting an injunction. That's also a criteria. And because there's a hearing, there's obviously notice to the opposing party. So if we go back to think about our initial chart and the executive branch and executive orders, and in this slide and the following slide, I'm presenting executive orders that have a theme with respect to the administration, the representative. So the first executive order, and this came out on January 31st last year, so this was one of the earlier tranches of executive orders. And this is reducing red tape. Right? For every new rule that an agency proposes, it shall identify 10 existing regulations for repeal. All right, so this is a very clear message as far as the goal to reduce red tape. And of course, I don't think there's a very big pro-red tape contingent out there. So this is a fairly non-controversial executive order. The next order here from the end of February last year, implementing the President's Department of Government Efficiency, Cost Efficiency Initiative. And of course, the Department of Government Efficiency is DOGE. And this executive order is the root of the defend the spend. Because what this executive order says is that the relevant agency, relevant agency in this case is the granting federal agency. So the relevant agency employee must promptly submit a brief written justification with request for payment for covered contracts and grants. So the agency employee must justify why they need a drawdown, whether it's you're apportioning your grant, they must explain why they're doing that. So this is why you are being asked to justify your expenditures, to provide more information so you can get the next payment. That's information that the agency could use to have your drawdown. And the goal of this, of course, is fraud prevention. But of course, it's not improving efficiency if you have to more frequently justify why you need funds. And we see this really throughout, especially if you think about it in a disaster recovery scenario, that the more you take up time making sure that everything is in order, that there's no room for fraud, the longer it takes you to get the funds out the door. In this next executive order, improving oversight of federal grant making essentially ensures that the agency terms and conditions, T's and C's, incorporate termination for convenience, right? So termination for convenience doesn't mean that the beneficiary, the recipient, necessarily did anything wrong, but the government has its reasons for terminating the contract. And they want the contract to state that if an award no longer effectuates the program goals or agency priorities, administration priorities, they can end the contract or terminate the grant agreement. And this is actually covered in the uniform guidance with close to this particular verbiage. So we've already have this incorporated into the uniform guidance. And the director here, the reference to the director, is the director of the Office of Management and Budget, who is now Russell Vought. And we know that Russell Vought is not a fan of indirect or overhead costs, or at least taxpayers covering indirect or overhead costs. So this executive order directs him to incorporate into the uniform guidance limits with respect to those overhead costs or administrative costs. So we'll probably be seeing that a little bit later in the year. So the executive branch issues executive orders, also memoranda. The Office of Management and Budget memorandum here, how we oversee, audit, and improve, basically puts the audit ecosystem, as they call it, on notice. And if you recall, very early on in the administration, within the first couple of weeks of the inauguration, there was a purge in the ranks of the inspectors general. And the administration was questioning their effectiveness as they are questioning the effectiveness of the entire audit ecosystem. And auditing should not be about reporting only. Mere reporting does not create improvement. That's the essence of this executive order. They want to identify which audit activities drive real risk reduction, accountability, and financial integrity. And as it says, compliance for its own sake is no longer the goal. Reporting is an action. And if you remember from the last webinar that we held, Mary Beth addressed this in the meaningful monitoring webinar, right? That meaningful monitoring isn't just checking the box for compliance, that it's asking, how is your program doing? Is the program itself accomplishing what it is supposed to accomplish? So that is certainly another theme of this administration, that we need to keep in mind on the receiving side of these federal awards, because there's a shift more toward outcomes than process than I think we're probably used to. And in addition to memos, of course, there are circulars. And this particular circular, A136, deals with financial reporting requirements. And this has been in existence for quite some time, but it was revised on July 14th last year. And this provides a single year format for federal agency audits. So once again, the pressure's on the federal agencies, and they're being held on a short leash, with the focus on the year being thought to be more conducive to precluding waste, fraud, and abuse in a timely manner. It's more real time. Right, so let's move on from the executive branch to the federal agencies and agency rulemaking. Now, I'm sure that you've all heard about the rescission of the endangerment finding or endangerment clause by the Environmental Protection Agency. This was literally in the headlines last week. The endangerment clause concluded that greenhouse gases were warming the planet and were harmful to our health, harmful to the health of human beings. So the government had to limit the production of those gases, do what they could to limit the production of gases. And again, this is consistent with the Clean Air Act. This is back in 2009. So the government would establish standards for emissions, not only for cars and trucks, but for power plants. So as you would imagine, this is a very, very big rule change with considerable consequences. And I would say it's almost a guarantee to wind up in the court system. But what's interesting is I heard an auto analyst speaking about the rescission last week, and I thought, the takeaway at first blush would be, wow, this is a great thing for the auto industry, one less burden for them to have to worry about. But as she points it out, the auto industry has invested considerable capital, in adapting, at the margin now for a less carbon-based energy, and at the margins, its operations were built, their manufacturing operations were built with certain emission standards, certain standards overall in mind. So to reverse that all now, to dismantle that now, would also take a considerable amount of time and money. And certainly if you're talking about the court system, litigation moving through the courts, that alone would take time. But furthermore, the political will could shift in 2028. We know that there will be a new administration. So her bottom line was you're not likely to see significant changes in the auto industry, at least over the short term. Another final rule that was issued on January 8th. Oh, actually, let me just return to the rescission. The EPA's rescission is actually a final rule, is in the National Register today. So it was announced last week, but if you'd like to read the actual final rule, all 111 pages of it, it is in the Federal Register today, because 111 pages because they also respond to comments from the comment period. So Department of Energy published a final rule on January 8th that, in a sense, deregulated or certainly decentralized the National Environmental Protection Act, or NEPA. And if any of your programs have involved construction, you're probably familiar with NEPA, and that it can be a laborious process. And if you have to conduct an environmental impact statement or provide an environmental impact statement, it could be costly as well. So before permitting a federal action or a federally funded action, the agency has to consider the environmental effects of an action by preparing an environmental assessment. And there are certain activities that are excluded from this assessment, called categorical exclusions. And an example would be, building a building that is, you're building a building, but you have already knocked down a building and you're putting the new building in that existing footprint. That would probably be a categorical exclusion. And the Council on Environmental Quality, this was part of the executive branch, is part of the executive branch, they established the national rules for implementation of NEPA that each federal agency had to follow. Well, what this rule has done, this revised rule, is gives each federal agency the freedom to determine their own implementation of these regulations. And to some extent, you think about it, the Department of Transportation is probably going to have a very different implementation than Health and Human Services would. So this is, again, giving each federal agency a less centralization. They make their own decision. And then in our last webinar, I think Mary Beth touched on the Child Care and Development Fund with more flexibility. And in two areas we highlight here, it was the case before this rule change that payments to providers, child care providers, had to be made prospectively. Well, now they can be made prospectively or via reimbursement. And the payments were based on enrollment. Now you can make those payments based on enrollment or actual attendance. And the thought being reimbursement or attendance are probably better ways to ensure for fraud prevention. And federal agencies also set standards. And in fact, the Uniform Guidance 2 CFR 200 is overseen by the Office of Management and Budget, as well as the compliance supplement that's published annually. And my understanding is that the compliance supplement for 2026 will be published in June. And I would say that's probably a strong likelihood that you'll see the director vote in that compliance supplement include the limits on the overhead or administrative costs that you can deduct from your grant. And of course, there are agency-specific policies, contractual terms, and an example would be the Department of Labor has their core monitoring guide. That's for the Employment and Training Administration. HUD has a monitoring handbook for its many programs. And then the Health and Human Services Department has a handbook as well. And I think we're all familiar with the legislative branch with bills. Bipartisan infrastructure bill included appropriations for the grid infrastructure and resiliency programs, including the state and tribal formula grants, which the 401(01)D grants that still seem to be okay in the sense of, not being at risk of being pulled back, and the GRIP programs. The One Big Beautiful Bill, of course, it includes numerous tax benefits. It also added to qualifications or requirements for Medicaid rather, and to encourage domestic investment. It permits full expensing of R&D costs and capital investment, which ultimately becomes a tax issue too, because if you can subtract greater expenses from your income, it's lesser income, lesser profit, and therefore your taxes are lower than they would otherwise be. So again, these bills are law. It's budget, it's law, and it's the legislative's branch uh, uh, liberty or freedom to apportion these grants and various federal awards, with, of course, the agreement with the executive branch. So, in terms of the judiciary, and some examples there, I'd like to kind of walk us through a case that was pretty much resolved, it looks like, and that was the state of Washington versus Federal Emergency Management Agency, or FEMA. And this came to the district court in Massachusetts, and it was concerning the FEMA Building Resistant Infrastructure and Communities, or the BRIC program. And BRIC is a very popular program. It's not disaster recovery. You know, we think of FEMA mostly as disaster recovery, but it's pre-disaster mitigation. And BRIC funds can be used for projects such as vegetation management and fuel breaks, for wildfire mitigation, and flood control measures like flood walls and levees, berms, wetlands restoration. And FEMA estimates that for every $1 it invests in mitigation, much as we think of it as a disaster recovery agency, every $1 they invest in mitigation saves it $6 in addressing the disaster, insurance payouts, and what have you. Well, on April 4th last year, FEMA issued a press release to announce that it's ending the BRIC program. And essentially, it was going to claw back funds that were not spent. And it was about $4 billion at issue in terms of being reallocated. So on August 5th, the district court granted the plaintiffs. Now, the plaintiffs were led by the state of Washington, but there were actually 20 states involved in total, represented by their attorneys general. Court granted the plaintiffs a preliminary injunction and froze the funds so that they could not be reallocated by FEMA. And on December 11th last year, the district court granted the plaintiffs, or the states, a summary judgment, summary judgment motion. Now, a summary judgment is granted, as it states here, on a claim for which there's no genuine dispute of fact or material fact. So FEMA, no question, FEMA issued this announcement. Everybody knows the funding involved with BRIC. States, obviously, everyone knows what was apportioned to each state. So there really wasn't a question of material fact. Therefore, you don't need a trial. But the moving party in a summary judgment is entitled to prevail as a matter of law, as they did here. So the district judge Stearns wrote, "This is a case about unlawful executive encroachment on the prerogative of Congress to appropriate funds for a specific and compelling purpose." Right? So Congress has the power of the purse through their budget. They basically are allocating funds. And does the executive branch, another branch of government, have the right to usurp that power and take those funds that are apportioned by the Congress and say, no, we're going to reallocate those over here? Well, this particular judge, this particular court said they do not have the power to do that. The executive branch cannot do that. So for this particular program, BRIC, that was the determination, the decision. FEMA has 60 days to appeal to the circuit court. Now, this was back on December 11th, so that deadline has passed for appeal. And I don't know if anyone else out there has heard, but I looked extensively, and I cannot find that FEMA appealed. Looking in PACER and court records and whatnot. So I would say that's a final decision then. Let's go probably to the most important and most interesting part of this presentation, which is, all right, so what can I do? How can I protect my funding? So it's maybe obvious, but comply with all the requirements. And with extreme diligence. Make sure every I is dotted and every T is crossed, because you don't want to give the federal government a reason to take your funding away. They don't hesitate, so don't give them a reason. And if you're making a decision that's outside what's governed by your normal policies and procedures, first, after you talk to your in-house attorneys, consult your awarding agency. Ask them what they think. This is a gray area. This is what you're thinking. What would they advise? And if they tell you, or if they don't advise you, document your support. Document the regulation or the guidance that you're relying on to support your decision. Or is it, experience? Is it industry practices? Past decisions by the federal agency, so that if you have this documented, at some point down the road, if an inspector general comes along and says, "Why did you make that decision?" then you have it all lined up and you can present that. Also, cultivate your partnership with your federal granting agency. Now, this probably sounds counterintuitive after we're talking about your funding being pulled back or reallocated, but think about all those executive orders that were directed to the federal agencies. Okay, the federal agencies are the first line of defense here. They're under the gun at the first order. So I think the approach that you want to take to your federal agencies is think Tom Cruise in Jerry Maguire, right? Help me to help you. It's a partnership. And clearly document. That's all you'll see throughout this is document. Document your subrecipient monitoring framework. And keep in mind, Vanderbilt Group, our business is oversight and monitoring for federal grants. That's it. So if you need some help with that, we're here. And don't forget that as of October 1st, 2024, you are now responsible for assessing your subrecipients' risk for fraud. So again, with the focus here on waste, fraud, and abuse, particularly, you don't want to fall short on that one. And in certain sections of the uniform guidance, as well as other guidelines, the regulator will provide suggestions, right? Or they'll say, you should, which isn't you must, right? Or they'll encourage you to do this. Again, it's not a shall. So we would suggest that you do what you should, even if it's not a must. And let me read an example here from, it was the compliance supplement for 2025. And they say for-profit subrecipients are accountable to the PTE, the pass-through entity, for the use of the federal funds provided. Okay? So they're addressing specifically for-profit subrecipients because for-profit subrecipients usually are not don't have a lot of experience with federal grants or federal awards. Methods to ensure compliance for federal awards made to for-profit subrecipients may include pre-award audits, monitoring throughout the performance of the subaward, and post-award audits. Again, this is ensuring the accountability of for-profit subrecipients. So in a fit of blatant self-promotion, the Vanderbilt Group actually does have, we call it compliance readiness assessment. It's a pre-award audit. And of course, we can monitor throughout the performance of the subaward rather than just one monitoring engagement. And we have focused on particularly, again, the energy companies, the states who have received, and again, they seem to be pretty safe at this point. The states receiving the state and tribal formula grant awards are required to pass those through to energy entities, for the most part, for-profit companies. So please keep this in mind, keep us in mind.
Liz, real quick, we have a question that relates to this slide, and I wanted to go ahead and jump in with it.
Yeah, absolutely.
So we have, the question is your professional opinion that we should perform site visits or we must for federal grant awards?
Again, I would say to be protective of your funding, to go the maximum length that you can, I would say treat the shoulds as a must.
Great, thank you.
So I would say, yes, that it would be a good idea to do this. Not required, but it would be a very good idea to do that.
Excellent.
Okay, and let's go back to, or take a look at the next element here in terms of protect your funding. Now, kill switch refers to the withholding or termination of your funding. And after you've received your award, if your risk profile changes in some way, maybe you've got findings from monitoring visit or audits, you failed to take corrective action, or was there some kind of a change in circumstances that introduced an element of risk that wasn't clear when you first signed your grant agreement or received these funds? And the agency can add specific conditions or really additional requirements to continue with your program. And they're addressed in 2 CFR section 200.208C. These conditions may include, with notification, notably, requiring reimbursement rather than advance payments, right? So that's a cautionary approach. Requiring additional or more detailed financial reports. I would say additional documentation also as proof of payment is due. Additional monitoring, additional prior approvals, and technical assistance. And to give you an example, when I worked in New Jersey, we worked with in the Sandy Recovery Division with over $4 billion in HUD funding. And we did well. We were very careful about our compliance with our requirements. So we had one monitoring a year. Well, during the course of this grant, we had a gubernatorial election. And the commissioner for the Department of Community Affairs was the grantee for the federal funds from HUD. And within the Department of Community Affairs, we actually were tasked with administering the grant. So HUD said, you've had these changes now at the very top, changes in leadership. So we're going to go back to monitoring twice a year instead of once a year, so we can see how that plays out, because this is an element of change that, again, we'd like to see that wasn't anticipated, so let's see how this plays out. And if these specific conditions are not successful, right, when the federal agency or the pass-through entity determines that non-compliance cannot be remedied by imposing specific conditions. So there's a sequence here, right? First, there's specific conditions. In other words, you have a chance to remedy the problem. If it cannot be remedied, then the federal agency or pass-through entity can temporarily withhold payments, pending a corrective action, completion of a corrective action. They can disallow costs associated with noncompliance. They can terminate the award. But again, this is after warning to the recipient. Now, ironically, in Minnesota, and we've spoken before about the Feeding Our Future scandal, which was quite a saga. And at some point, the Department of Education in Minnesota began to have some concerns about Feeding Our Future, and they specifically observed that the nonprofit status for Feeding Our Future had expired, had lapsed. And also that the CPA who provided Feeding Our Future single audit was not actually a CPA, right? Was not a registered CPA. So they began to require more extensive documentation, and they began to stop processing additional provider applications. And the judge in that case decided that the Department of Education could not do that. They had no grounds to do that because Feeding Our Future was not given adequate notice about the specific conditions. They weren't told why those specific conditions were being applied. And then they started to cut back or started to essentially terminate the award before they saw what happened with these specific conditions. Were the specific conditions successful? And if you look at the transcript, the judge literally told the state, the Department of Education, that they were not complying with the uniform guidance. So we have the kill switch, know the sequence for the kill switch. And we have an article actually on our website that goes into more detail about this, that is located via the media tab on our homepage, or I believe that's also in the chat for your convenience. Okay, so to wrap up, protect your funding, adopt and memorialize. Memorialize, again, document fraud prevention, detection, and reporting measures. Also, what happens if you do detect fraud? Include your escalation provision. Who do you report this to? And certainly do not ignore suspected fraud. And we, the past 6 months or so, had a series of webinars that addressed all types of fraud, different aspects of fraud. And the data analytics and AI were part of this webinar called Detecting Fraud in Grant Programs and Data Analytics. And you can access this particular webinar as well as the series on our homepage. And if your program particularly is data rich, right, you have lots of applications, you've got lots of supporting documentation, you would be wise to deploy a proprietary artificial intelligence tool, because AI can pick up on trends within the data or inconsistencies within the data that are not obvious. So use artificial intelligence to supplement your human intelligence, again, particularly if you're dealing with a lot of data. And if your program is in serious jeopardy, not because of noncompliance on your part, remember the BRIC case. Reach out to other states. If your program is at risk, their program probably is too, and there's strength in numbers. And there are also templates out there from prior litigation. And just as a general proposition, strengthen your internal controls. Right? You want to just demonstrate that you are a responsible steward of taxpayer dollars. That's the bottom line. Okay, so at this point, please type your questions into the Q&A feature. We will take questions. There's no time limit for questions. I'll stay here. And let me just run real quickly while you do that through some of the services that we offer, some of our programs. And I always like to say that the Vanderbilt Group is in business to keep you out of trouble. So this is how we intend to do that. And of course, we talked about meaningful monitoring. And our platform, will vet your program for compliance, obviously, but will also foster compliance, help you foster an environment of compliance. Agent Tipster, I've also touched on. This is our AI tool. And believe me, I'm a huge fan of human intelligence, but there's no question that artificial intelligence is a terrific supplement when it comes to identifying risks to your program that are not obvious, but could nonetheless be quite significant. So Agent Tipster, you can see it described here. Again, this is all accessible on our homepage. We have a comprehensive platform that we call Guardrails 360, and it establishes a foundation for long-term compliance and reporting, as well as fraud prevention and detection. And I think this is most helpful if you're just setting up your grants compliance system, or if you're experiencing a pattern of non-compliance, you've got findings, and you need to attack that situation in a more comprehensive manner. Guardrails 360 is something you may be interested in. And then the Defend the Spend Navigator, we again talked about Defend the Spend, and we can help you set up your infrastructure for repeated, will be repeated drawdown requests and the supporting justification for those. And then finally, we offer technical assistance and training. And as a member, as a pass-through entity, you're responsible to make sure that your subrecipients or subawardees are compliant with program requirements. And we can provide a comprehensive rundown of what those program requirements are, for a subrecipient, or provide a training for a specific tricky compliance area like procurement. And I actually was introduced to the Vanderweel Group from our need for assistance in setting up a monitoring unit for the ARPA funding when I was at the state. So we stand ready to help you in a variety of ways for your compliance and oversight needs. So Jess, do we have any questions?
Yes, we do. Thank you so much for that presentation, Liz. We
Sure,
have one so far.
Yes.
Like I said, y'all don't be shy. Toss your questions in the Q&A feature. I'll be happy to answer them for you. The first question that we have is, what is the difference between a temporary injunction and a preliminary injunction?
Okay, well, a temporary injunction or temporary restraining order is almost like slamming on the brakes. It comes as a result of an emergency. And to give you an example, there were 5 states that had funds frozen a few weeks ago with under suspicion of fraud. And it was Minnesota, New York, California, Colorado, and Illinois. So they received a letter from, I believe it was Health and Human Services on a Monday or a Tuesday, that you have to present this documentation by Friday, to alleviate our suspicion of fraud. So immediately the states went to the courts because they said this requires a tremendous amount of effort to get all this documentation together. So they requested that the court, and again, this is an emergency, so a hearing is not required. It's just up to the court to decide, okay, you need more time to get your motion for a preliminary injunction together. Right? So the court gave them 2 weeks in which to get their briefs together, and actually they did receive a preliminary injunction. But that was they started though with a temporary injunction that got them 2 weeks to get themselves organized.
Got it. All right. Is there any other questions? Give just another minute or so. And please, if y'all wouldn't mind, please let us know what you thought about this presentation in the chat. Also, if you have any recommendations or anything that you'd like to see in a future webinar, please feel free to share that, because we would love to hear what y'all thought about it, and also too what y'all would like to see. So, all right, well, if there are no other questions, thank you, Liz, again for presenting today. It was absolutely informative and fabulous.
It was my pleasure. And by the way, thank you all so much for participating. And if you have any questions, follow-up questions, you have my contact information, as well as our president, Mary Beth Vanderweel.
Yeah, absolutely. We got one other question that slid in. So it says, as for the previous slide with compliance, you said there was a handbook that was published and provided for sub-recipients. Could those handbooks be replaced by contract only?
Okay, so do you mean the compliance supplement?
I believe
I'm sorry,
that is
so a contract wouldn't replace, say, the uniform guidance. It should incorporate, though, the uniform guidance. But the grant requirements, the federal requirements are the requirements. So a contract would not supersede that.
okay.
I think if I didn't answer your question, let me know. Let us know.
Okay. All right. Yeah, absolutely. Feel free to reach out to us. We'll be happy to answer that question for you, or schedule a meeting, quick call. Well, once again, thank you, Liz. And if you would like to watch this webinar again or share it with colleagues, refer back to it as a resource. The video recording will arrive to your inbox in a couple of days. You can also view our previous webinars on our website. If you would like to receive invitations to future webinars, you can sign up for our mailing list on our website as well. We will be hosting a webinar in March, so please watch your email and our social media for that announcement. And if you're not already, please like and subscribe to our social media outlets. If you have any additional questions regarding the information that was presented today, you can email Liz or Mary Beth using the contact information on your screen. Furthermore, we encourage you to visit our resource library to discover a wealth of grants oversight resources to help you manage your grants program. Our resource library can be found on our site at vanderwiltgroup.com/resources. All the links are posted in the chat as well as presented earlier today. Thank you again for attending our webinar, and we hope you enjoy the rest of your day.
Thank you.